Judgment in the appeal, Birmingham City Council against Abdulla and others.
Lord Wilson will give the judgment.
174 claimants bring these claims in the High Court. Almost all of them are women, and for convenience, I will refer to them simply as the women. The defendant is Birmingham City Council. In the past, all the women appear to have been employed by Birmingham. They allege that Birmingham broke their contracts of employment, as a result of which they are entitled to damages. They allege that Birmingham broke the equality clause included in their contracts by the Equal Pay Act 1970, now replaced by the Equality Act 2010, which provided that if, as they contend, they were employed on work rated as equivalent with that of men in the same employment, their terms of employment should have been no less favourable than those of the men. The women's claims have not yet been heard. A preliminary point has reached the Supreme Court, for Birmingham has applied for an order that their claims be struck out. It has invoked the power to strike out, which was given to the court by Section 2(3) of the 1970 Act, in cases in which claims of breach of an equality clause could more conveniently be disposed of by an employment tribunal. Birmingham's application has been refused by the trial judge. Its appeal against his refusal has been dismissed by the Court of Appeal, and now it appeals to this court against the Court of Appeal's dismissal. What complicates Birmingham's application is the fact that if the claims of the women were struck out on the basis that they could more conveniently be disposed of by the tribunal, and if as a result the women were thereupon to present their claims to the tribunal, they would at once be dismissed by the tribunal on the basis that it was too late for the women to bring the claims there. For each claim is what is described as a standard case, and by Section 2(4) of the Act, it had to be presented to the tribunal within 6 months of the end of each woman's employment. In the cases of all these women, that period has long since passed. So the issue boils down to what the words more conveniently mean in Section 2(3) of the 1970 Act, and in the subsection of the 2010 Act, which has now replaced it. By a majority, this court dismisses Birmingham's appeal. 3 members of the court hold that a claim for breach of an equality clause can never more conveniently be disposed of by the tribunal if it would there be time barred and so couldn't get off the ground. They consider that the notion of convenience requires the court to conduct a straightforward, practical inquiry into whether the court or the tribunal is better suited for inquiry into the merits of the claim. But 2 members of the court disagree. They are concerned, in particular, by the substantial reduction in the effect of the 6 months time limit for presentation of a claim to the tribunal, if instead, after that time, the claim can often, as in each of the present cases, be issued in court. So, in order to give what they regard as necessary effect to that time limit, they would have conferred a wider meaning upon the words more conveniently. They would have accepted that the fact that a claim would be time barred in the tribunal would be highly relevant to whether it would more conveniently be disposed of there. But they would not have accepted that that fact would be conclusive, nor even nearly conclusive, against a strikeout of the claim in court. They would have allowed the appeal so as to send Birmingham's application back to the High Court for it to consider, in the case of each woman, whether, in the light not only of the reasons why she failed to present her claim in time to the tribunal, but of all other relevant factors, it would be in the interests of justice for her claim not to be struck out.
The court will now adjourn.